to the Green Law Group's first in a series webinar, How to Survive and Prosper in the COVID Economy. I'm Scott Green. I'm the managing partner of the Green Law Group. I've been practicing law since 1978. I've seen a lot of ups and downs in the economy, but nothing like this. If your business is going to survive, you're going to have to adapt to the new COVID economy, and we're here to help. And this series of webinars is designed to give you a leg up on your competition. So before we get started and I introduce your speakers today, I'd like to thank our sponsors, beginning with Easy Law Construction Notices. You want to secure what you earn, use Easy Law for your preliminary notices and mechanics liens. Also like to thank Ventura County Contractors Association, Builders Bookstore, Ventura County Credit Union, and the Blue Book. So although you can hear me, hopefully, you're on mute. So we're not going to hear back from you until we get to the Q&A at the end of the presentation. But we'll have a Q&A, and if we should miss you on the Q&A, you're certainly welcome and invited to send us an email. Our next seminar in August will be on, the title will be How to Secure and Collect What You Earn. It'll be all about contracts, preliminary notices, mechanics liens, etc. And tell a friend. We've got spots for 100 or so. We expect to fill up, so reserve early, and you know, we're going to make it worth your while. Excuse me while I deal with a slight technical challenge. Our PowerPoint is not moving. Oh, there we go. Okay, so fair warning, you know, what you hear today in the presentation is going to be general legal comments. For specific advice regarding your particular matter, please follow up with us separately, as this is meant to be generally educational and not specific as to anyone's particular situation. With that, I'd like to hand it off to our speakers today. The first speaker is Mike Khalilpour. Mike is the head of our business department. Mike's going to talk about specific COVID issues in business, and then he'll be followed by Matt Bechtel. Matt is the head of our employment department, and there are tons of issues there. So with that, enjoy the presentations from Mike and Matt, two very outstanding attorneys that I'm delighted to work with.
Good morning, everybody. So the first kind of major topic that we wanted to cover was how to address delays, not just with customers, but on construction projects, and how to kind of go about dealing with the issues that arise when you're facing, whether the delays are caused by lack of, you know, materials or supply chain delays, whether it's employment related, or municipality related when it comes to, you know, inspections and just dealing with the city or county. The first kind of major thing to try and be cognizant of is that you want to try and anticipate these disruptions early enough and communicate those delays, whether it's on material deliveries or any kind of supply chain issues with the owner, or moving it up the chain if you're, say, a subcontractor, to the general contractor and then on to the owner. You want to make sure that these are typically in writing and that you describe what the issues or what the delays are going to be, what's causing them, whether it's on the employment side, whether it's on the supply chain or delivery side. And you want to address these in a manner that's consistent with your contracts. So what we typically recommend, and what I always recommend as well, is look to your contract to see what key terms are there as to delay provisions. Now, typically there's going to be a force majeure clause that deals with delays or unanticipated consequences. However, some of the bigger kind of template agreements, whether it's the AIA docs or consensus docs, they don't typically deal with, and they don't have a specific force majeure clause. They deal more with delays, unavoidable consequences. And so what you want to do is make sure that you've reviewed your contracts and you know what and how to provide notice to the customers or to the general contractor if you're a lower tiered sub. The next kind of step in that process is to make sure that, to the extent that these delays are you've been able to calculate that you provide not just the notice, but you provide change orders or other forms that might be required on that specific project. And the reason you want to do that is you want to make sure that if these delays are going to cause any issues with respect to the critical path or construction schedule, you don't want to be on the tail end of a project and have dealing with chargebacks or any kind of delay damages from either the general contractor or the owner. Other issues that can kind of come up with the delays are if it's outside of your control. So it's not employment, it's not materials, that's caused by inspections. Inspections can be delayed. A lot of building and safety departments are still currently not scheduling certain inspections and not sending out inspectors in a timely manner. So to the extent that there are any kind of delays or any anticipated issues that arise from those inspections, you want to make sure that you're communicating early, often in writing, and you want to identify and make sure that the way you're providing notice, whether it's up the chain or down the chain, is consistent with your contracts. And I say all of that to say it's a good idea to make sure, and you're reviewing all of your contracts, or you can contact our office. We provide general counsel services to review your construction contracts, to make sure that these kinds of issues, these delay issues, are adequately addressed. The next kind of topic that is less construction oriented and more on the business finance side is making sure that you know what you've signed up for, whether it's the payment protection loans or if it's an EIDL, which is an economic disaster injury loan from the SBA. And the reason is both of these loans, and I'll go through them one by one, both of these loans are meant to provide liquidity for certain aspects of your business to make sure that you're able to withstand or survive this disaster that's been declared. Now, first part, the economic injury disaster loan, which is a loan that's offered directly through the SBA. You don't have to go to a lender. You go on the SBA's website. There's a portal that allows you to seek these funds. This loan, although it provides funding for your business, you want to make sure that you know what you're actually signing up for. These are long-term loans, typically 30-year repayment plans that are very low interest. I believe it's 3.75% interest. There is a grace period for repayment. However, the kind of catches that come with the SBA EIDL loan is that there are collateral requirements to the extent that the loan you've sought exceeds $25,000, and that collateral can include a combination of all personal property and or real property, depending on what assets you have. Because what the SBA does when you apply for the loan, in addition to all of your personal information through the application and your prior tax returns. They also do run a credit check, so they want to make sure that to the extent that you are able to provide collateral for the loan, that it is provided. There's a few additional kind of strings attached to this loan that might not be readily apparent. Couple of the major kind of bigger issues that come up is, notwithstanding the collateral, is there's restrictions on what you can use the loan proceeds for. So for the injury disaster loan, you can only use this loan for working capital to alleviate the quote unquote economic injury that's been caused by this disaster. So you can't use it to do things like relocating your business. You can't use it for things like expanding your business. It has to be to try and bring in that infusion of cash to survive, in order to survive and then kind of make it to the other side of this bridge. Other kinds of things that you should be cognizant of, so to speak, is that to the extent that you're using these loans to purchase equipment that may be necessary for the business, you have to make an attempt to only purchase American-made equipment and products. That's kind of one of the little lesser-known requirements of as far as the use of proceeds go. In addition to that, there are also record keeping and retention requirements where you have to be able to provide the SBA at any point in time after a request is made a full accounting of where these funds have gone and how they've been used. And that records retention is for the 5 years until the maturity of the loan. So on a 30-year loan, which the EIDL loans are typically on a 30-year maturity date, you have to keep all of your records for up to 35 years. And they're subject to audit and inspection at any point in time by the SBA during the life of the loan. The other kind of major loan that's been out there and discussed, some at length and some not, is the PPP loan. I'm sure a lot of you have heard of the PPP loan. Typically, it's still available. I believe it was last on July 3rd. The president signed an extension that allows for eligible businesses through the first week of August to still apply for this loan. And this type of SBA loan, it's through the Section 7A program of the SBA. It's not, the loan isn't processed through the SBA directly. You do have to go to your lender, so whoever you bank with and or other lenders that are out there that can process the PPP loans. Few things to kind of watch out for as far as the PPP loans go is, one, to the extent you guys may have applied for the loan, you only get one opportunity. You cannot apply for multiple PPP loans, even though there might still be funds available for that loan. You can only apply for one loan. Certain other issues that we've seen arise are the ineligibility criteria is a little bit different than traditional SBA loans. So for instance, owners that own 20% or more of a business that have either been, that are currently either on probation, parole, or even subject to an indictment or an arraignment are not eligible for the PPP loan, whereas they're not automatically disqualified for the EIDL loan. The use of proceeds on PPP loans also are a little bit different, and you want to, again, make sure that you are adequately keeping records. And the best practices approach that I've recommended to all of our clients is to put these funds in a separate or segregated account. And that way, if there's ever an issue as far as audits or records are concerned, it's very easy to point to one separate account or one separate bank and show where the funds have gone. The use of these proceeds are typically the restricted by things like payroll. Payroll does include wages and tips or any kind of vacation or sick pay that you might be obligated to pay to the employees. The amounts that are excluded, however, are the employer's portion of your Social Security and Medicare taxes and the federal unemployment tax. And if you don't know what those are, you definitely want to talk to your payroll provider or your bookkeeper or CPA. So to the extent that the employer's contribution for those taxes, they cannot be paid for by the PPP proceeds. Other items that the PPP proceeds can be used for are things like mortgage interest, other business interest, rent, and utilities. Now, recently, with the passage of the Flexibility Act, there was a change in percentage. Prior, under the CARES Act, there was a breakdown of 75-25. So what that means is the 75% of the PPP loan had to be used for payroll and payroll-related expenses, and 25% could be used for non-payroll-related expenses. With the passage of the Flexibility Act, that ratio was reduced to a 60-40, so that now you can use the up to 60% of the PPP loan for payroll and up to 40% for the non-payroll aspects. However, one thing to be cognizant of, whereas with the prior CARES Act, that 75-25 breakdown only came into play with respect to the forgiveness portion of the loan, the 60% cutoff is deemed a cliff. So if you do not use at least 60% of the PPP loan for payroll and payroll-related expenses, no part of the PPP loan will be deemed forgivable. And so that's kind of a big thing to watch out for when you, one, are applying for these loans, and two, are administrating or using the funds from this loan. You want to make sure that you use the percentages or keep track of the percentages, so you don't inadvertently use a ratio or use a higher percentage for non-payroll related activities. Also, another thing that we've seen, or at least I've seen some misconceptions on, is the repayment period for the PPP loan. If the loan was procured prior to the passage of the Flexibility Act, the repayment term remains 2 years. After the passage of the Flexibility Act, if you received your PPP loan, or if you're applying now to get your PPP loan, the repayment period is extended to 5 years. So if you got your PPP loan in March, April, or May, you're still on that 2-year repayment plan. And as far as the kind of last step of the the payment protection program is the forgiveness part and how to apply for forgiveness. So that's typically your lender. If you do have a PPP loan already, your lender will have the application process set out for you. It's very kind of formulaic, and I would highly recommend using either your CPA or bookkeeper to make sure that you've properly filled out the application, so you're able to have as much of the loan forgiven as you can. And that's just kind of a function of the SBA takes into account the number of employees you had during the February 15 to December 31st, 2019 time period, to the number of full-time employees you have in this year for that same time period, or for the time period where you were using the PPP loans. And using that ratio, it comes to what percentage of the loan is forgiven or can be forgiven once you submit the application and the supporting documentation. Now, as with the EIDL loan, the PPP loan also has a record retention requirement, which is a little bit different. You're supposed to keep all the records and be able to show the funds tracing essentially for a period of 6 years after either the date the loan is forgiven or the date the loan is paid in full. So if you have a PPP loan that you pay in full in 2 years, then you have to keep these records for 6 years after that 2-year period. So it's a period of 8 years from, let's say, today. That is my section kind of this presentation. So I'm going to now pass it off to Matt, who is our in-house employment guru. that.
All right, hello. I can't see myself on this. I'm Matt Bechtel. I'm the head of the employment department at the Green Law Group. Today I'm going to be talking about matters specific to the employment side of things. Now, when we initially put together this presentation, we did it because pretty much the state and all the counties had released their stay-at-home orders, and everyone was allowed to return. Now, as of Monday, the governor started to reverse that and issued an order that actually closed down many businesses. So the first question that was added very recently was, can I resume operations? Now, if you're in the construction industry, nothing has really changed. In fact, you never really had to shut down because you were an essential business. If you are in an industry other than the construction industry, there's a possibility that you are subject to a shutdown order. If you're an essential business, you can still stay open. If you're not, or if you're in the pretty much in the entertainment or bar industry, you are forced to shut down. But if you're not in the construction industry and you have any questions about whether or not you're allowed to continue operating, you should contact us. Now, obligations to employees. This firm represents both employers and employees. That gives us a very unique perspective. And one thing that we do is we get a lot of calls from employees complaining about things and asking, is this legal or not? That's kind of what guided a lot of these issues that we're going to talk about. The first is wages and salaries. We've received a lot of calls from employees saying, my employer cut my wages, they brought me back, but they're paying me less than they were before. Is that legal? The general answer is yes. Now, you got to be careful that you comply with any minimum wage requirements. So if it's an hourly employee and you're in the construction industry and you're a prevailing wage employee, you got to pay the minimum wage for all the hours worked. You got to pay overtime, just like you always had to do. You can reduce wages, the hourly wage if you want, as long as you're above the minimum wage. Now, if you have salaried employees, and this is where we get a lot of calls and where employers really have to be careful. If you have a salaried employee, there are specific requirements that the employee be paid at least twice the minimum wage, but more importantly, they have to be paid on a salary basis. Now, what that means is you can't dock their pay for any reason. So if you're going to bring an employee back at a lower salary than they had before, then you need to change their salary up front and you need to maintain that salary going forward. Without docking. Now, the general rule is you can dock an employee's pay if they miss a full day's of work due to their own personal reasons. So if you shut down, if you tell the employee they can't come in or operation is going to be shut down, you still have to pay the employee for that day. If the employee calls in and says he or she can't come into work and the reason is not because of a sickness-related reason, in that case, you can actually dock the pay. Now, the second issue is workers' compensation. We've got a lot of calls, and this is from our employer clients saying, can my employee file a workers' compensation claim if they get COVID while at work or once they've returned to work? The answer is yes. Now, about 2 months ago, Governor Newsom actually issued an order that has since expired, so it's no longer in effect. But the order basically created a presumption that any employee who gets COVID after returning to work or after working within a 14-day period will be presumed to have gotten the contracted COVID at work. Now, that order has actually expired. It's likely it might be renewed at some point, but at this point it has not. But nonetheless, employers or employees can still file workers' compensation claims if they do contract COVID. Now, your workers' compensation carrier will do an analysis and figure out whether or not it was a work-related injury, but whether they got it at work or not. The third question we get a lot is maintaining health coverage. Now, this really comes up in the context of employers who've opened back up, but they're opening up on more of a limited basis, and they're bringing back employees who were previously full-time and are now working part-time hours. And the question is, do I have to maintain health coverage for those employees? And the answer ultimately depends on many factors. Now, if you are bound by the Affordable Care Act, if you have over 50 employees, there are different requirements, and you should contact us specifically if you have questions about that. Most of you and most of our clients tend to be smaller employees with less than 50 employees. Now, if you have less than 50 employees, the general rule is you have to maintain health coverage if an employee is taking or eligible for a job protected leave. Now, typically, if you have less than 50 employees, there's 2 job protected leaves that are available right now in California. There's pregnancy disability leave, which won't apply to most of you, but if you have a woman who is either disabled by pregnancy, is pregnant, or has a condition related to her pregnancy and needs leave and takes leave for that reason, you have to maintain health coverage during that time. And we'll talk more about this in a moment, the Family First Coronavirus Relief Act, which actually created an extended FMLA leave for pretty much all employers, including employers with less than 50 employees. Now, if you're not familiar with FMLA, it's a federal law that grants up to 12 weeks of leave. You only have to comply with it if you have over 50 employees. California has a similar law known as CFRA, which has the same requirements. You have to have over 50 employees. But the extended FMLA leave that we'll talk about in a moment, that applies to all employers, even if you have less than 50 employees. So if an employee is taking leave based on that, you do have to maintain health coverage during that time. Absent a job protected leave, your only duty to maintain health coverage if you're a smaller employee is based on your own policies. Now, if you have a policy that says all employees, including part-time employees, are eligible for health coverage, then you need to maintain that coverage. If you don't have such a policy, or your policy is you must work full-time in order to have health coverage, in that case, if an employee falls below the minimum requirements of your policy, you can discontinue coverage for that reason. Now, the third issue that comes up a lot is sick pay and sick leave related to COVID. Now, California has a law that mandates every employee gets 3 days of sick leave. If you're in the city of LA, they've extended it to 6 days of sick leave. That sick leave applies, and you still have to provide that. But a couple months ago in April, the federal government passed the Families First Coronavirus Relief Act, which is a law. This is the law that extended the FMLA, and it provided 2 weeks of sick leave for COVID-related issues. Now, we previously issued a newsletter that covered this in more detail, so I'm not going to go into all the details. That information is available on our website. But generally, this law applies to any employee who is subject to a quarantine order, has been advised by a healthcare provider to self-quarantine, or is experiencing COVID-19 symptoms and is seeking medical diagnosis. If you are in any of those or your employees are in any of those situations, then you do have to provide up to 2 weeks of sick leave. If they're a full-time employee, that's up to 80 hours of sick leave. If your employees need to miss work because they have a child who is either out of school or their child care provider is no longer operating because of COVID, you also have to provide sick leave for those employees. The sick leave for those employees is at 75% of the employee's pay for up to 2 weeks. Now, the extended FMLA leave is limited to employees who have to be out of work to care for their child because their school or their child care provider is closed. So in that situation, you also have to provide an additional 10 weeks of leave for a total of 12 weeks. And again, that leave is paid at 75% of their normal pay. If any employee who is taking leave for the first 3 bullet points in this in the slide that's in front of you, that leave for the 2 weeks is paid at 100% of their pay. Now, the Department of Labor has created an eligibility tool for employees it might be helpful for you to look at too if you have any questions of whether or not the employee is eligible for the leave. And there's a link to that tool down below. Now, the Family First Coronavirus Response Act, Relief Act is actually the name, applies to all employees with under 500 employees. Now, there is a required notice that every employer must provide. That notice will be available on our website. It's a poster just like the other posters that you should have on your job, hanging up at your place of work with other leave requirements and the minimum wage and all that. There's a supplemental poster that you must provide, and you can download it from our website. Now, I'm not going to go into detail about different return to work protocols, but I did put some resources on, up here for you to review. Now, if you're in Ventura County, in order to reopen, there is a set of procedures that you must attest to and certain protocols you must follow. All the information can be found at the website that's on the screen, vcemergency.com/vcreopens. If you're in LA County, the LA County website has very specific protocols that are broken down by industry. There are probably about 20 different ones that you can look at that's specific to your industry. That can be found at publichealth.lacounty.gov/media.coronavirus. Again, those links are on your screen right now. The last thing I want to talk about is avoiding discrimination and retaliation claims. We are expecting to see a huge increase in employees bringing claims for discrimination and retaliation based on COVID. And this is something that we think is going to be ripe for litigation in the next year or so, starting sometime in the next few months. And we want you to be prepared to avoid those discrimination and retaliation claims to the best of your ability. Now, there's no guaranteed way to avoid an employee bringing a discrimination or retaliation claim. When employees tend to get fired or no longer have their income, they tend to turn to attorneys to look for some relief. And attorneys tend to look for any basis that they can to allege a discrimination or retaliation claim, which would allow them to collect back wages. If in the end you terminated an employee, it would allow them to collect the wages from when you terminated forward. So the best way to avoid such claims is have a uniform policy for everything that you do regarding granting leave requests, regarding allowing employees to come back to work. And one thing that you got to be careful of is there's a California law called the Fair Employment and Housing Act, which basically makes it unlawful to discriminate for various reasons, including disability. Now, disability is defined under FEHA as both an actual disability or a perceived disability, which means if you treat an employee as if they have COVID, even though they don't have COVID, you're opening yourself up to a discrimination claim for disability discrimination, even if it turns out the employee didn't even have COVID. So the first thing you want to do is, no matter what you do, is have a uniform policy regarding when you grant leave, why you grant leave to different employees. If you're going to require tests to have employees come back to work after they've had a COVID diagnosis, you want to make sure that you apply that equally to everybody. If you pick and choose only some employees, the employees that don't have to follow the protocol can come back and say, well, the real reason you did it was some other protected class, and therefore you're discriminated against them. And the other thing you want to be careful of is you want to make sure you comply with the shutdown orders and any orders relating to opening up. Another form of discrimination and retaliation that is common is employees who complain about unlawful activities. So, for example, if an employee comes forward and tells you, other employees are not wearing masks, but the law requires it, and you dismiss that, and you take adverse action against that employee now just made a complaint about an unlawful activity. If you take an adverse action against that employee based on that complaint, then you're opening yourself up to a discrimination or retaliation claim. So you want to make sure that you are following all of the guidelines. And if an employee complains about anything that they perceive to be illegal, before you take any action, you want to make sure that what they're saying is accurate or not. And if they are accurately, complaining about something that's illegal, you want to rectify the situation and make sure that you start complying with the law. Now, a third area that I think is going to come up a lot is what about when employees employees are in a high risk category for COVID and they don't, and they want to return to work. The question is, do you allow them to return to work? So for example, if you have an employee that's over 65, is in a high risk category, they say they want to return to work, you think it's not safe for them, you tell them not to return. Don't do that. Again, that is treating them that is disability discrimination, because that is treating them as if they have a perceived disability. Now, you can advise your employees, you're in a high risk category, we think coming back might be dangerous for you, but leave it up to the employee to decide if they want to return or not. Now, the last thing is testing. I briefly spoke about this before. An employee gets COVID, and before you allow them to return to work, you require them to have a test. Now, that is not illegal. You can actually require a test to allow them to return, but you shouldn't enforce the rule if for any reason they're unable to get a test. And right now there's huge delays in testing, so there's a real possibility that someone won't be able to get a test. And there's also the real possibility that a lot of tests are coming back positive even after a long time has elapsed since the person contracted COVID, and based on the passage of time, they should have cleared it. So right now the guidance says, and you should follow it, is you can require a test. If the employee tells you that they can't get a test for any reason, you should just use a passage of time system, and you should wait at least 10 days after their symptoms have subsided, meaning after they no longer have the COVID symptoms, and then allow them to return from that point. Most people are doing 14 days quarantine once they have, and then at the end of the quarantine, you allow them to come back. Again, you can have a policy that says get a test. You just want to be careful when the employer comes or the employee comes back and says, I can't get a test, or I took the test and I haven't gotten the results yet, and it's been 3 weeks since they've contracted COVID. At that point, you want to let them return unless there are some factors that lead you to believe that they're still a threat to other employees. They still have it. And again, if they no longer have any symptoms, you should let them return at that point. Now, the last question that I received several times is, what if my employees just don't want to come back to work? You've opened back up, you've called the employees up and said, we're operating now, and they said, I just don't feel comfortable going back to work because I'm afraid of getting COVID. What do I do in that situation? Well, the answer is really up to you. You can terminate an employee if they don't come back to work and you've opened back up. My recommendation would be to work with them to the degree that your company can allow it. So if it's not going to hurt your business operations, if you can allow them to not work, then go ahead and allow them to not work and come back when they're comfortable. It's a personal decision the employer has to make, and the decision is going to be based mostly on a business decision, what works best for your company. But the general answer is, can you fire that employee for not wanting to come back? The answer is yes, but I give you one caveat. You want to make sure that you're complying with the stay-at-home orders and with the return to work orders. If you tell an employee to come back to work, but you're subject to an order to stay shut down, that will be a discrimination claim. If you are clear to open up and the employee doesn't come back, at that point you are free to terminate the employee if you choose. But again, I recommend that you be as reasonable as can and accommodate employees to the extent that your business allows it or is capable of doing. With that, I think we'll open it up to questions. Okay, I'm told that there's a way for you to type in a question if you have them. So if you have any questions, feel free to type them in and we'll take them in order.
Where do they come up if they're typed? Oh, Matt, you can see them.
Okay.
First question.
So the first question is, for Ventura County and construction business, we didn't shut down. Do we still have to attest? The answer is no. It's a reopening requirement. I would recommend that you still do it, and I would recommend that you follow the protocols that are there. And you are required to still follow the protocols, but I don't believe you actually have to attest. Now, the next question is, which is more of a question for Mike, can EIDL we use to pay off debt, credit cards, loans, etc.?
Yes. As long as you can use the EIDL for all purposes related to and the natural consequence of the national kind of disaster that's been declared. That can include debt service of existing debt, whether it's to pay them down or pay them off. You just want to make sure that you're keeping records of how much was paid and what was paid into where. And then ancillary, you want to keep records of the underlying debt that was paid off. So make sure if it's, for your business, you're not paying off your personal credit card debts, that they're the business credit cards for business expenses that were incurred, and you can use the proceeds to pay off the business debt. Yes.
Expand it.
There.
Okay. So next question is, can an employee open an unemployment claim? Sorry. Can an employee open an unemployment claim if they are the ones choosing not to come back to work due to COVID-19 fear? I'm expecting there's going to be some specific regulations issued regarding this. As of right now, the rule has not changed. The general rule is if an employee is not returning to work, if an employee is unemployed or has a reduction in hours of work through through no fault of their own, they can get unemployment. If it is through a fault of their own, they cannot get unemployment. But I do expect that to change. I do expect there to be a regulation that allows, in certain limited circumstances, that an employee can seek unemployment if they don't want to return based on specific criteria. But again, right now there is no such provision.
Next question is, are the workers' comp costs included in payroll? I think that's a reference to the use of proceeds on the PPP loans, and the short answer is no. as far as the 60% threshold. And then as far as the 40% threshold, those again, the use of proceeds are things like rent, utilities like gas, water, power, rent on business equipment and real property, and the interest payments on business debt. So not the principal, but to the extent that you're paying interest on debt, then the up to that 40% threshold can be used for non-payroll expenses. But as far as the 60% threshold, workers' comp, it is not included. It's just the actual payroll, wages, tips, any kind of leave, whether it's sick or vacation, and that's basically it. That question. Next question is there a time frame to submit a PPP loan forgiveness application? The forgiveness application, you should apply for it once the once you've used the proceeds of the PPP loan. I believe the timeline to apply for forgiveness is 10 months after the covered period. So the covered period was extended by the Flexibility Act to 24 weeks or December 31st, 2019. So hypothetically speaking, if you've used the entirety of the PPP loans by December 31st, 2019, then you would have 10 months from that date to apply for forgiveness. But I would recommend that you should start that application process as soon as the funds have been used. This one. Next question, if the PPP loan was approved in May, does the 75-25 apply or the 60-40? So with the Flexibility Act, the 60-40 applies. However, the drawback to that is the 60% rule is now considered a cliff, so that if you don't abide by that 60-40 rule, the entirety of the PPP loan is deemed unforgivable and you are subject to repayment. The only part of the Flexibility Act that does not apply for PPP loans that were funded prior to the passage of the Flexibility Act is the repayment period. That still remains 2 years from the date, it remains 2 years from the date of disbursement, and not 5. So if you saw or have received the PPP loan after the Flexibility Act was passed, then that repayment period was extended to 5 years. But for those issued in May, it would be the 2-year repayment. If your employee, so next question is, if your employee does not come back to work because he is getting more money with unemployment claim, are you charged back for those payments? I believe that's a reference to the unemployment insurance reserves that are paid into. To the extent that, and this might be a hybrid question for Matt and myself, to the extent that an employee fails to return to work that would otherwise be required to return to work, you would have to, I believe, and Matt, correct me if I'm wrong, you'd have to proceed with terminating the employment and then notifying the EDD appropriately of that termination so that the unemployment claim can be addressed and any kind of issues with the UI reserve can be addressed at that point.
I think that's correct.
All right, any other questions? Get to them all. We answered that one. Oh, we can delete. Okay. We answered that one. Okay. No more questions?
All right. Well, thank you. Thank you for coming to the webinar. The next webinar will be in August. Again, there is information on our website, specifically the FFCRA information. We do have a PowerPoint up there that has a lot more information as well. If you have any questions specific to your situation, feel free to email either myself or Mike, and we will respond as quickly as we can. Thank you for participating.
Hey, good job, guys.